Section 20. Legal Hotline Q&A. Fair Housing Practice. In the Market. Introduction. The details that can cost you your license. As we move into this final legal hotline section, we focus on the details, the small decisions that agents often overlook, but that can create major legal exposure. In 2026, compliance is not just about avoiding obvious discrimination. It is about understanding the fine print, advertising rules, accommodations, accessibility, and policy enforcement. These are the areas where even experienced agents can make mistakes. This section will walk through real-world questions that highlight how easily a situation can shift from compliant to illegal. Scenario 1. Equal housing logo requirements in advertising. A licensee wants to advertise a property and is unsure what size equal housing opportunity logo to use. The answer is that HUD does not require one single size. It depends on the size of the advertisement. However, there are clear guidelines. For example, a half-page ad should include a larger logo, while smaller ads may use a smaller version, or even just the equal housing slogan if space is limited. The key takeaway is that the logo must be visible and proportionate to the advertisement, and if other logos are used, the equal housing logo should be at least as prominent. This is not just a suggestion, it is part of educating the public and demonstrating compliance. Scenario 2. Assistance animals versus no pets. Rules. An individual with a disability, such as AIDS, has an emotional attachment to a small dog in a community that prohibits pets. Can the rule be enforced? The answer depends on necessity. If the animal is required for the individual to have equal use and enjoyment of the property, it is considered a reasonable accommodation and must be allowed. If the animal is simply desired and not necessary, the rule may be enforced. This highlights a key principle. Necessity determines protection under fair housing law. Scenario 3. Charging pet deposits for assistance animals. A landlord wants to charge a pet deposit for a tenant who has an assistance animal. The answer is no. Under fair housing law, assistance animals are not pets. Charging a deposit or fee for such an animal is considered discrimination because it places an additional burden on a person with a disability. As long as the accommodation is reasonable and does not create an undue burden, it must be allowed without additional cost. Scenario 4. ADA compliance in commercial buildings. A commercial office building built in 1960 has a bathroom door that is too narrow for a wheelchair. A tenant now has an employee who requires wheelchair access. Must the door be widened? Yes, most likely. Under Title III of the ADA, both the landlord and tenant are responsible for ensuring compliance in places of public accommodation. Even if the building is older, barriers must be removed when it is readily achievable to do so. Widening a doorway is generally considered a readily achievable modification. Even if the lease assigns responsibility to one party, both the landlord and tenant remain legally liable. This is a critical concept. Contracts may allocate responsibility, but they do not eliminate liability. Scenario 5. Pool barrier policies in families with children. A property management company requires tenants with children to install a fence or comply with swimming pool barrier laws and then remove those improvements at their own expense at the end of the lease. Is this policy compliant? Probably not. Familial status is a protected class under fair housing laws. Policies that impose additional conditions or burdens on tenants with children can be considered discriminatory. Even if the intention is safety, the policy must be applied in a way that does not single out families with children for different treatment. This is a key reminder. Policies must be neutral and applied equally to all tenants. Why these scenarios matter in your daily business. Each of these examples highlights how compliance often comes down to small decisions. A logo size, a fee, a policy, or a design feature can all create liability if handled incorrectly. As a real estate professional, you must follow advertising guidelines carefully, understand the difference between pets and assistance animals, recognize ADA compliance requirements, avoid policies that create unequal treatment. These are not just best practices, they are legal requirements. The final takeaway: compliance is in the details. By this point in the course, you've seen how fair housing and ADA laws apply across every part of a transaction. The final lesson is simple. Attention to detail is what protects you. When in doubt, ask questions, consult your broker, seek legal guidance. Because in today's market, one small mistake can lead to a major consequence. Online discussion. Question 1. Why is the equal housing logo important in advertising? Answer: it demonstrates compliance and informs the public that housing is available to all without discrimination. Question 2. When must an assistance animal be allowed in a no-pet community? Answer: when it is necessary for a person with a disability to use and enjoy the property. Question 3. Why can't landlords charge fees for assistance animals? Answer: because they are not considered pets and charging a fee would be discriminatory.